Hey everybody, the employer-sponsored green card process, also referred to as the PERM process, has recently undergone some significant changes, and I wanted to put out a quick video to keep you in the loop with some of the changes that are taking place, that have technically already started to take place. In a moment, I'm going to share my screen with you, go over some information about this. Hope you find this video valuable. If you're interested in an employer-sponsored green card, or if you're an employer looking to sponsor somebody for a green card by giving them a job offer, and this is information that you should be aware of, make sure to stick around. Hey everybody, so as I mentioned, the Department of Labor has announced some significant changes to the employer-sponsored green card process. A little while ago, I recorded a detailed video where I explain how to get an employer-sponsored green card, and we go step by step through all the requirements, all the process, and it's very detailed. That's not the purpose for today's video, but I do want to provide you with some background information. The purpose of this background information is to help these updates make a little bit more sense. So when you apply for an employer-sponsored green card, the first step is to file a prevailing wage determination. This is basically where the employer will say, this is the role that I have available. This is the title of the job. These are the duties. This is the experience that's required. This is where the job will be located and all the details. They'll submit that prevailing wage request through the FLAG system. It's basically this online portal system where you'll input this information. It's called FLAG. And after several months, the Department of Labor will come back with a wage that is associated with that position. And the employer is required to at least pay the foreign worker that they're sponsoring for a green card. They must at least pay them that amount or more. So that's the prevailing wage determination process. After the prevailing wage determination, there is a recruitment process where the U.S. employer has to show that they tried to recruit a U.S. worker and they were unable to successfully find a U.S. worker for the position. And after that's done, then the employer can file the PERM application, technically called the ETA 9089. Now, traditionally, this PERM application was in a separate website. It was basically separated from the FLAG system that we talked about earlier with the prevailing wage request. But as of June 1st, PERM applications, the ETA form 9089, is now also being submitted in the FLAG system. So that's first and foremost for you to understand the big change that's taking place. It's that this application is now being processed and filed in the FLAG system. While that might not seem so important, what I do want to mention is that now with this new kind of application that's now being processed through the FLAG system, we've also observed some changes in this application. And I want to highlight some of those changes. So take a look at my screen and we'll go through them. So I want to highlight just some of the changes to the PERM application, also called the ETA 9089. Of course, this is not an in-depth analysis of all the changes. I just wanted to point out some of them, and we'll talk a little bit more after the presentation. So the new form asks for the number of employees on payroll in the area of intended employment. The Department of Labor is asking, in this particular area where you want this foreign employee to work, how many employees are on payroll? The new form also asks a question about dual representation. The question is, has the employer contracted with an agent or attorney that also represents the sponsored foreign worker? Interesting question that's being asked there. Moving on. The new form also asks about the type of work site that the foreign worker will be working at. So whether the work site is the employer's business premises, whether the work site is the employer's private household, or whether the work site is the employee's private residence. So there's a question about that. And the new form also requires filers to complete an additional appendix and to provide a business necessity justification when affirmatively answering whether proficiency in a foreign language is required or preferred to perform the job duties, or when answering affirmatively to the fact that the job opportunity involves a combination of occupations and more. So just to quickly explain what this means. So in the new form ETA 9089, if the position requires proficiency in a foreign language to perform the job duties, and on the form ETA 9089 you answer yes to that, then you're required to complete an additional appendix and to provide a business necessity justification for that, basically justifying why the foreign language is required to perform the job duties. Similarly, if the job opportunity involves a combination of occupations, for example, if it requires the foreign worker to do a little bit of this and a little bit of that, and it seems like there's a combination of occupations that are involved, and you answer yes to that, then the form ETA 9089 similarly requires the filer of that form to complete an additional appendix and to provide a business necessity justification for that. Basically, to provide a justification for why this position requires a combination of occupations. And there are multiple other circumstances where the employer or the filer would be required to complete an additional appendix to provide a business necessity justification. There you have just a few of the changes that are on the form 9089. Now the question is, what should we make of these changes that we're seeing? Well, in many ways, it's too early to tell how these new PERM applications are going to be adjudicated because, again, this new system was just implemented and put into effect as of June 1st. But as you saw in that last part of the presentation, I was going over two examples of scenarios where the filer of the form ETA 9089 would have to provide a business justification for requiring proficiency in a foreign language or for requiring a combination of occupations. And what's interesting is that those two scenarios that I just outlined are oftentimes situations where the Department of Labor will audit a PERM application. So when you file the ETA form 9089 and you file the PERM application, hopefully it just goes through and it gets approved without an audit. But in some cases, the Department of Labor will audit the application. Sometimes these audits are random, and sometimes there are things that you will put in the application that may trigger an audit. One of those things in the past has been foreign language requirements. And you might want to think through why that is. Well, if you're hiring a foreign worker for your position, chances are that they speak a foreign language. The Department of Labor wants to make sure that you're not tailor-making a role based on the employee that you're seeking to bring in, that you're not crafting a role based on their skill set. So sometimes when you require a foreign language, the Department of Labor will audit that to make sure that there's actually a business need for that foreign language skill to be able to perform the job duties. And you're not just putting it in there to craft this role around the skills of the foreign worker and to make it harder for US workers to qualify for the position. Similarly, with that second scenario that I outlined, where the position requires basically a combination of different occupations. Again, this is a scenario that might trigger an audit historically because the Department of Labor wants to make sure that you're not just looking at your ideal candidate, this foreign worker that you want to bring to the US, and you're not just structuring a role around their skill set, but in fact, this is the business necessity. Again, historically, these have been scenarios that may trigger an audit from the Department of Labor, but now we're seeing the PERM application affirmatively require the filer of the application to justify the business necessity for these things affirmatively, rather than waiting for an audit. So it's just an interesting observation. Time will tell whether this new PERM application elicits more audits or less audits, and whether it will ultimately result in more PERM approvals or less PERM approvals. We'll see. But again, for this video, I just wanted to share with you this update. I hope you like this video. Hope you found this information informative. Please make sure to hit the like button, hit that thumbs up button, subscribe to our channel if you haven't yet subscribed to our channel. Thank you so much for tuning in. We're all about empowering you with knowledge, so the more people that can watch this video that can benefit from this information, the better. Again, thanks so much for tuning in, and I'll see you on the next video.